Woman in St. Peter's who is allergic to grass, and so they decided to take the grass out of their front yard and to plant what can only be described as a very nice garden. And then St. Peter's passed a law saying, no, you must grow grass. She took it to court, and yesterday a federal judge said no, she does not have that right, and the judge apparently sided with St. Peter's. Her attorney, Dave Rowland, joins us now. Dave, welcome to Big 550 KTRS.
Thanks so much for having me on the show.
What did the judge say yesterday?
So the big question in front of the court was, are property rights fundamental rights under the Constitution? The Duffners say, look, we're using our property in a perfectly harmless, perfectly lawful manner. In other words, the flowers themselves are completely lawful. We should be able to choose for ourselves what we do with our property rather than have the government dictate to us what we're going to grow. And the judge said, nope, you don't have this right. This is not a fundamental right under the Constitution. There's also the issue of the penalties that are imposed. St. Peter's has a law that says if you are out of compliance with their turfgrass mandate, you can be charged up to $250 per day plus the option of 10 days in prison per day that you're out of compliance. The Duffners have been out of compliance for 4 years now, so the potential penalties they're facing are hundreds of thousands of dollars in fines and decades in prison if the city wanted to pursue that.
Dave Rowland, with all due respect, you must be a terrible lawyer. Doesn't it say doesn't it say somewhere in the Constitution that I have a right to property, to own property, and therefore
it absolutely does, yes. So both the 5th and 14th Amendments talk about the right to property. This is a right that predates the Republic. This goes back to the days of England and the common law there. And we pointed that out to the judge. We said, look, this is nothing new. This is something that courts have recognized for more than 200 years. But nonetheless, he says, well, we don't think that these rights are fundamental. That puts him in line with a number of judges over the last 80 years. And in fact, that's why we took this case. We think that property rights are fundamental rights. They are deserving of protection. And this is one of the most egregious violations of property rights I've seen in 15 years of doing this kind of work. So we feel like we're going to keep pressing this. We're going up to the 8th Circuit Court of Appeals, and we'll take it to the U.S. Supreme Court if we have to.
As of now, she still has her garden, right?
That's correct. They refuse to comply with the turfgrass mandate for now. We are going to continue fighting this, and they have no intention of complying with the grass mandate unless the court absolutely orders them that they have to, and that hasn't happened yet.
So from what I understand, she put in the garden, and then the town of St. Peter's changed the law, right?
That is correct. Yeah. So they bought the property in 2002 and immediately started working to remove the grass from the property. The ordinance was adopted in 2008. The city has some photographs that they say show grass on the property as of 2008. It's debatable. And ultimately, we decided that rather than argue over that, we would just stick to the constitutional principle and try and advance that cause.
Yeah. You said that there are this case has the judge ruled. Explain yourself. The judge ruled that people don't have this right, and you're saying that's been. Sounds like the judge followed the law, or explain what you meant there, that there were other judges that have ruled similarly.
Okay, so in cases going back almost to the beginning of the country, courts have talked about the right of property, including the right for people to make a lawful, harmless use of their property. They would talk about it in terms that are not similar to the way that courts talk about rights now. So they acknowledge the right, but they never labeled it a fundamental right, which is what courts do now when they talk about constitutional rights that they think are very important. And so we're trying to get the courts to acknowledge, hey, look, this is actually a fundamental right. It's a right that's been recognized for all of these years. Call it a fundamental right, and now courts have to apply higher levels of protection, and that's what we're really aiming for.
Dave Rowland, certainly many people can understand the plight of this poor woman who is allergic to grass, right? I mean, that's why she's doing this. But that doesn't matter, right? I'm not allergic to grass, but if I wanted to have a garden in my front yard, don't I have that fundamental right? So the allergic to grass is an interesting angle, but that really doesn't matter in the end.
Yeah, you're absolutely correct. The fact that she's allergic to grass just highlights how absurd the law is, but it doesn't change the constitutional situation. Our perspective is anyone who owns property ought to be able to use it in a lawful, harmless way of their own choosing, not that the government dictates to them. So this is really a case that applies to everybody.
What do you say to the person who says, okay, fine, she can grow a garden, but then you know what? My other neighbor, he can put a broken down truck in his front yard. That's legal, but it's an eyesore. You can open up a strip club next to me. That's terrible for the neighborhood. I don't want to be looking at a strip club, but you have that right. There's a yin and a yang to this argument.
So I think that the distinguishing point is whether the property use poses any serious concern regarding the public health and safety. So if you've got a broken down vehicle, arguably you could have, danger from rusting metal or leaking fluids or things like that. There's at least arguably a public health and safety angle there. But when we're talking about flowers that are perfectly legal by themselves, that pose no threat of harm to anybody. And in fact, the judge pointed out, yeah, these flowers haven't harmed anybody. They don't pose a likely threat of harming anybody. Then that removes the health and safety angle, and there's just no remaining justification for the government saying, no, you can't do this with your property, or even worse, you must do what we tell you to do with your property.
There must have been a couple of neighbors who didn't like the flowers and then complained to City Hall, and so the squeaky wheel got the oil, right? I mean, that's what's going on here.
My understanding is that is how this thing kicked off. My understanding is that one of the neighbors didn't like it and went to the city and complained, and that's why the city sent the enforcement notice to the Duffners back in 2014.
This is costing St. Peter's quite a bit of money, I would think.
Yes, I'm sure that it is. The funny thing is, we don't know exactly how much it costs because St. Peter's refused to give me the invoices for their attorneys, which they're supposed to under the Sunshine Law, but they said, oh, the Sunshine Law doesn't apply here because you're an attorney asking for this. You've got to ask for this through a different process, and oh, by the way, we're not going to give you the records anyway. So I actually don't know how much it's costing them. I would love to find out.
Now, you're taking this case pro bono?
Yes. The Freedom Center of Missouri, the organization that I founded with my wife, we represent our clients pro bono. We work only for donations, but it's because we believe in these causes. We believe that all citizens have the right to have their constitutional freedoms protected, and we never want our choice of cases to depend on our client's ability to pay. Because quite frankly, the people who get targeted with constitutional violations are usually people who don't have the resources to fight back. So that's why we're out there on the front lines taking on these issues.
Jan Duffner seems like a lovely woman. I'm looking at the photo of her and her husband in the garden. What is she thinking about all this? Did she ever think it would get to this point?
Oh, I don't think she did. She's frustrated. I spoke to her the other day when the decision came down, and she's very frustrated because they've been fighting this for years, and they don't understand why it's such a difficult issue. It should be simple. It should not require going and spending years in litigation just to vindicate your right to grow a beautifully maintained flower garden. But yes, Jan and Carl are lovely people, and it's just so unfortunate that they're bearing the brunt of this ridiculous law.
What's the next step now?
Next step is in a couple of weeks we will file our appeal to the 8th Circuit, and then we'll go through the briefing schedule, and we'll have an argument probably in about 9 months. But it's definitely an issue that's not going away anytime soon. We're planning to contact groups all over the country to come in and weigh in on this issue when we get it in front of the 8th Circuit.
And my last question, Dave, and that is this. Since this story broke some point yesterday, what has your phone call, what has your phone list been like? National media outlets calling you?
No, nothing national yet. We've had a lot of interest here in Missouri, of course. I do see that a couple of news outlets across the country have picked up on the story, but I haven't spoken to anyone nationally yet. If they want to call, I'm happy to talk to them.
Yeah, and then you'll go on Fox, MSNBC, CNN, and then we'll try and call you, and you'll never return our phone call. We know how this works.
Not true at all. I would always love to talk to you.
Dave Rowland with the Freedom Center of Missouri. Never a dull moment around here, Dave. You're always welcome here, and I'm sure we'll be talking to you in about 9 months or so.
All right.